Well,
Not a problem.
we're happy you joined us here for the meeting. So, with that, I will call the meeting of the Chicago Board of Election Commissioners regular meeting for Tuesday, April 29th, 2014. Good morning, everyone. My name is Langdon Neal. I'm chairman of the board. And to my left is Commissioner Marisol Hernandez, and joining us by phone with agreement of the commissioners is Commissioner Richard Connolly. First item on the agenda is the consideration of the agenda. Any additions, deletions for the record? Hearing none, we'll plow through here on item number 3, which is the minutes. We have available for review and approval minutes for the meeting on Tuesday, April 8th, 2014.
Motion to approve?
Moved by Commissioner Hernandez.
Second.
Seconded by Commissioner Cowan. Further discussion? Hearing none. All those in favor?
Aye.
That'll be the order. We'll move on to the Executive Director's report. Mr. Goff.
Thank you. Just to let the board members know, we've been still working on debriefing meetings. I know Ms. Bateman and Mr. Allen had a meeting with ES&S yesterday that lasted about 4 hours to go over the electronic poll books. I also at that same time had a meeting with Mr. Kramer from Dominion to work on our maintenance agreement. Hopefully we'll have something for the members to review for the next board meeting.
Okay.
But everything else seems to be, we're just trying to go over all the different problems that we had and make sure we correct them so we don't have them for this upcoming election. But everybody's on board and they seem to know what they have to do to correct it.
All right.
I feel very comfortable.
Once you get all those review and comments, you'll report to us as to...
We're going to have the key staff give a report to the board members.
Okay.
So it'll be key staff that will give that report.
Okay. Good. Anything else for you, Mr. Goff?
Nope.
Okay, I'll turn it over to Ms. Bateman. Good morning, Ms. Bateman.
Good morning. Sorry I was late.
Okay.
We met yesterday with ES&S to go do our post-election debriefing of how the poll book went. Obviously there were lessons learned, things that we need to improve going forward to November. Again, we still believe that it was a successful implementation. But you know, we still have some work to do, and it's good that we're able to start sooner. So we're going to start our weekly conference calls in mid-May. So we will move forward with that. And I'm sure Mr. Goff said everyone else is just working. You know, still doing post-election reports and that. We still have a federal report that's due. That's pursuant to the grant that we were awarded a couple of years ago. That's due in mid-May. So that's it. Everything else is working going well.
Okay. Any other questions for Ms. Bateman? All righty. Communications Director, Mr. Allen.
Over the last couple of weeks, we've had a few visits and meetings. One meeting of note was with the Joyce Foundation and the Presidential Commission on election reforms, hosted by, or co-chaired by Governor Romney's attorney and campaign attorney, and President Obama's campaign attorney, and you moderated that event. It was, I think it was very well received, and it was refreshing that many of the items that the commission recommended were items that we either have in place or that we're putting in place, including the state with online voter registration and the electronic poll books for security and for voter services. We've got a canvass coming up, and we're trying to determine to what degree we can use the household mailing that we recently did for the primary for canvass purposes, at least as a first notice, and then follow up with a second notice, and or the possibility of a full canvass. We're still weighing all the postage costs. We had a full canvass, of course, last year. At a minimum, we would do an NCOA canvass, but we're weighing the importance of doing that full canvass now ahead of both the November and the February elections. Last week we sent letters to the party chairman for the Republican and Democratic committee, or Democratic parties in Cook County, advising them that the schedule for placing judges of election, and we set a deadline of July 7th for the first list, for the initial list. The statute allows for much earlier, but July 7th is the first list, and then there will be supplemental lists after that they can supply. But we emphasize with both chairmen that we want to make sure that we have adequate time to assign and train all of the judges. And lastly, as Kelly noted, we had some productive meetings with Dominion and ES&S. A lot of the focus was on early voting and then just different enhancements, and they want us to get a priority list to them as far as what projects they want us to tackle, or we want them to tackle first. That's it.
Well, I will chime in because although you gave it very matter-of-factly, Mr. Allen, as we always do here, I think a tremendous amount of recognition should go, and I don't hesitate bragging about the Chicago Board of Elections, as we all know. But if you read 100 pages of the presidential recommendation, it was a bipartisan commission made up of, headed by the chairman of Mitt Romney's campaign and the chairman of President Obama's campaign, two very distinguished lawyers. If you read all 100 pages of the recommendations, it reads like our own infrastructure and operational manual. I can't think of one recommendation from the commission that we're not already undertaking. It's really stunning. I had a chance to speak to both co-chairmen, and they were really, I think, quite impressed with the things and how far we've gone even beyond that in terms of actually implementation. So they're traveling around the country, and I don't think they'll be spending a lot of time here because they don't need to spend time here. But I really, it was a proud moment for, I think, the Chicago Board of Elections in recognition by the Presidential Commission that we are actually on the forefront of all these changes in how elections are administered in this country. So I'm going to brag about it. So.
Well, I would just add that in addition to your comments, Chairman, I think a lot of the credit goes to our staff and our senior leadership and the leadership of the board, because these are not easy things to accomplish.
Well, you also, we're going to recognize you too, Commissioner Cowan, because you were instrumental in crafting and developing our infrastructure project and plan, which again was almost a model for the recommendations of the commission. So,
well, thanks, Lang, but as you've said, it's a team effort, and none of this could happen just through one person's effort. It's a team effort and a team result.
Well, it was really very impressive. So.
I'd just like to ask, Jim, there isn't any question, is there, that we're going to have a full canvass considering the November election and then followed very quickly by the municipal elections?
We're working on that.
We're working on our canvas plan.
Lance indicated we're working on that.
Okay, because just my opinion, voicing one view, I think we should have a full canvass because of the importance of both of those elections. There's always budgetary concerns, but I think keeping the rolls as clean and as accurate as possible is one of our highest priorities.
Well, we're going to do our best, Commissioner. We tried to sharpen our pencil as far as how much we spent on the household mailing for the primary. We greatly reduced how much that cost, going with the bilingual and then separately the quadlingual were necessary, and then the standard postage rate as opposed to first class on that one. So we're hopeful that if we can squeak out enough savings for the fall mailing, that we might be able to make room for that as well.
Okay, I would just like to hear a report next meeting striking the if.
We'll report at the next meeting as to where we stand on that, for sure.
Okay, thanks.
Commissioner Hernandez, anything you wanted to?
No.
Okay. All right, we will move to old business. I don't think we need to say anything more on infrastructure. The electronic poll books, Ms. Bateman reported on. Mr. Goff, voting equipment, Mr. Goff. Anything else to?
Nothing else.
I recognize Mr. Kramer's in the audience, as well as Paige. Anything from Dominion this morning?
Just echo the sentiments on the working staff.
Okay. Legislation.
Mr. Chairman, nothing to report other than the fact that the legislature is back in session this week after a 2-week recess. So,
Jim, just a
schedule.
question. Anything happening on the bills relating to the use of schools as polling places or the right of schools to opt out?
The bill that was introduced earlier that would have allowed school districts to opt out has been referred to the Rules Committee in the House and the Assignments Committee in the Senate. So it does not appear that either of those two bills has any momentum. There is another bill, I believe it's 2855, that would clarify that election authorities have the right to use polling places, schools as polling places, and encourages school districts to declare Election Day either as an Teachers Institute Day, or as a special holiday, so that children would not be in school on those days. But again, that's encouraging school districts to do so. It's not a requirement. That bill is moving forward and did advance prior to the recess, so there is a chance that that bill may pass.
Thanks.
Though I did happen that evening to spend some time with a high-level Chicago public school administrator, and he says that he didn't think that school districts were not going to go back to the School Institute Day. It's just not they don't want to lose that day for some reason.
Well, that seems to be consistent with the position they've taken in the past. There's a reluctance to do that.
Yeah. Okay. Under new business, I think this is your report, Mr. Scanlon.
Yes, Mr. Chairman. One of the cartage companies, it performed services for the board for the March 2014 primary election, is, at least in my opinion, in material default and in breach of the agreement between the board and the company. And the company in question is Rio Movers and Van Lines, Inc. That's 7001 South Chicago Avenue. And I believe and submit that the company is in breach on at least 4 grounds. One, at the time of its bid submission and at all times continuing thereafter, Rio did not possess a valid motor license. Motor carrier of property license from the Illinois Commerce Commission as required by law. It did not at the time of the bid submission, nor does it have thereafter, a valid license from the City of Chicago to conduct business in the City of Chicago as required by the municipal code of the City of Chicago and by the agreement. Further, Rio did not, at the time of its bid submission, pay all fines, fees, and taxes or charges due to the City of Chicago and remains indebted to the City of Chicago, which is one of the reasons why they were not issued a valid business license by the City of Chicago. And number 4, that they materially falsified and misrepresented its qualifications and its bid submission. And for those reasons, it would be my recommendation to the board that the board issue pursuant to section 8.01 of the agreement a notice of default and breach and notify Rio of the grounds for breach and default of the agreement, and to give Rio 15 days to cure such breaches and defaults, and to report back to the board why Rio should not be held in default of the agreement. And that would be my recommendation to the board.
Questions for Mr. Scanlon?
I would just move to, what would be the motion to adopt the findings, preliminary findings, and issue the notice of breach and default?
Correct, to issue notice to Rio of the material breach and default of the agreement, and to provide Rio 15 days after receipt of the notice to cure such default or otherwise explain why Rio is not in default of the agreement.
So moved.
Moved. I'll
second.
Okay, seconded by Commissioner Cowan. Further discussion? Hearing none, all those in favor?
Aye.
Aye.
Jim, at this time, would this be moved to litigation or?
No.
Or no? It would just be by negotiation?
Right, all this is the notice. I mean,
Okay.
They have 15 days to respond. So
Okay.
At this
So
point in time, there's no need for litigation.
Okay.
And I do have a letter for the commissioner's signature.
Okay. Jim, we'll move on to your legal status report.
Mr. Chairman, on Friday, the U.S. Court of Appeals for the Seventh Circuit affirmed a decision of the United States District Court in the matter of J. Stone versus Board of Election Commissioners. The plaintiffs in that case have challenged the constitutionality of 3 Illinois statutes. One is the minimum signature requirement for mayor, city clerk, and city treasurer, which is at 12,500. Another section of the Illinois Election Code, Section 10-4, that requires candidates to collect petition signatures within the 90-day period before the filing of the petition. And the third requirement is Section 10-3 of the Election Code, which limits persons who sign nominating petitions for independent candidates to signing only 1 petition for a candidate per office. The plaintiffs claimed that all 3 requirements, either separately or acting in tandem, were unconstitutional, placed an unconstitutional burden on candidates' right and access to the ballot. The Federal District Court granted the board's motion to dismiss, and the Seventh Circuit has now affirmed that decision. I don't know if the case is going to move further. I think, based on communications I received from plaintiffs' lawyers, it does not appear to be the case, but we'll have to wait and see.
Okay. Well, congratulations, Jim, on a fine piece of work. And it was a long and arduous litigation process. And I'm certainly pleased. I think all the commissioners are pleased with the result.
Well, thank you, Mr. Chairman. Thank you, Commissioner. And I also should add that Terry Burns and Paul Malik at Dykema Gossett were very helpful and instrumental in securing this result, so they deserve a good portion of the credit for this as well.
Yes. Okay. Anything else from your legal status report, Mr. Stanley?
No, Mr. Chairman.
Then we will move to financial report. We have voucher listings for the City of Chicago, voucher number 1404. The agenda is incorrect. 1404 dated April 29th, 2014, in the amount of $496,874.95. $496,874.95. Is there a motion?
Motion to approve.
Moved by Commissioner Hernandez,
Second.
seconded by Commissioner Cowan. Further discussion? Hearing none, all those in favor?
Aye.
Aye.
We also have a voucher listing for the County of Cook, voucher 1405, dated April 29, 2014, in the amount of $288,624.20. $288,624.20.
Motion
I'll
to,
move approval.
Moved by Commissioner Hernandez, seconded by Commissioner Cowan. Further discussion? Hearing none, all those in favor? Aye.
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 Will be the order.
Clarification, is it $288,824.20 or $288,624?
Oh, I'm sorry.
Did I say something incorrect?
Well, there's just
So
two
is it-
different
is it on the
amounts
agenda?
on the agenda amount and then on the actual.
It's 288.
Oh, yes, okay.
The record needs to be correct.
Let's correct the record. Thank you, Mr. Burrell. It's $288,824.20.
Both correct.
288,824.20.
And,
So we'll do a new motion.
yes, I'll move to approve.
Moved by Commissioner Hernandez.
Second.
Thank you. Seconded by Commissioner Cowan. All those in favor?
Aye.
Aye.
That'll be the order. Thank you for those eagle eyes, Commissioner. All right. At this time, we will move to the public comment section. Is there anyone here who wants to address us today? Oh, Ms. Maroney. You raised your hand first.
Oh, okay. Good morning.
State your name.
Sharon Maroney. I'm speaking at this moment with Defend the Vote, and I wanted to discuss the issues relating to provisional voting. I noticed that in the legislative report today that had not come up, and would like to request that this board get involved in the problem from a legislative perspective that you're going to be facing in November. Currently, as it stands, Defend the Vote has alleged, and actually the State Board of Elections has agreed, more or less, that it is voter extortion or it is unlawful to not count the constitutional ballots, votes on the provisional voting. I know Mr. Scanlon was copied into the email, and they have totally changed their opinion now at this point on provisional voting, and in order for someone to get a provisional ballot, they must believe that they are in their residential precinct. So the scenario that we all faced in the primary is no longer going to take place. So I think that's a great victory for everybody. But we still have the secondary problem of the fact that when one vote is cast on a provisional ballot, it automatically negates or casts a negative vote for any constitutional amendment or referendum that's on that provisional ballot. And there is no remedy in the law as it stands right now, so either we're going to have a situation come up in November where 7,000, potential 6,000 votes are disenfranchised from their constitutional amendment, or everybody has to have a process by which they let each voter know that by gaining one right to vote or have their ballots counted, they have now cast an absolute negative vote on the referendum. So I was seeking to see if this board would use their resources and contacts within the legislature to ask for this problem to swiftly be resolved at that level, because apparently, according to the Board of Elections, that's where it has to go. That's point number one.
I don't understand point number one that you're making.
Well, I think one of the issues that Ms. Maroney referred to is a question of how to treat provisional ballots for purposes of constitutional amendments.
Okay.
Because where you have a constitutional amendment, the question becomes whether or not a vote that's not cast, it constitutes a no vote.
Okay.
Because usually the requirement is that it has to be passed by a percentage of individuals voting,
Correct.
even if they don't vote on the question itself.
Right, they take a ballot.
Right. Under the current procedures and under the current statute, provisional ballots cast in the wrong precinct are partially counted. And they're only counted for certain offices, statewide offices, countywide, citywide, congressional districts, legislative districts, House districts. There's no mention of counting provisional ballots cast in the wrong precinct for any kind of referendum, whether it's a constitutional amendment or any other binding referendum,
Oh, I see.
or even advisory referendum. So there is, and Ms. Maroney's correct, she shared with me a copy of some correspondence between her and Ken Menzel at the State Board of Elections that addressed some of these issues. Ken had put together a draft of a response that I believe that they're intending to send to the Joint Committee on Administrative Rules, JCAR.
That's correct.
And I have not seen a final draft of that, so I don't know what their message is going to be, but apparently they are in the process of writing something to JCAR to address some of these issues. But that is an issue with regard to constitutional amendments and how those provisional ballots would be counted or not counted, as the case may be. There are other issues too, I think Ms. Maroney raised.
I think they've resolved the majority of those by restricting the access. You know, prior to that, anybody that lived in the county could vote in any polling place, and they have restricted that now to the voter has to have reasonable belief that they live inside the precinct. And I think that I have not seen the full comments myself, so I'm speaking off the cuff, but in my view, that curtailed the spread of, out-of-precinct provisional voting to probably the intent of the people who wanted to make sure that people who voted at least had some of their votes count, which is the claimed reason for this law. However, it still has a huge problem because we're going to have a whole bunch of constitutional amendments on this upcoming ballot, and it's going to be a mess if we do not deal with this problem of if they don't. I mean, surely any of these forces that have the funds that are fighting this are going to want to go to court and challenge these ballots. I would say proactively, let's get it resolved, because surely it is a form of voter extortion to say, not that you guys are doing it, but if the state legislature is saying you have the right to have some of your votes count, but the only way you can do that is by having a no vote on the constitutional amendment, logistically, you can't get one right and then force them to vote because of that. And that is the way the law is set up as it is now.
So Jim, what's the status of this at the moment, of this particular issue?
Prior to the March election, the State Board of Elections had adopted and implemented emergency rules, and those are the rules that were in effect for the March primary election. Those rules expire, I believe, in July. And so then they have to go to permanent rulemaking. And so that process will continue to move forward. And during that process, JCAR, the Joint Committee on Administrative Rules, can accept and consider public comments. I'm not sure, Ms. Maroney, did you or someone submit comments directly to JCAR? Okay, so this is the period, the rulemaking period within which JCAR can consider public comments. I believe the State Board is in the process of drafting correspondence that I think addresses Ms. Maroney's questions, at least in part, and perhaps they have other issues as well. So, hopefully before the November election, we will have some permanent rules in place to the extent that any legislation is necessary to modify those rules. Of course, we have another month while the General Assembly is in session to address those as well. So that's where we are.
I guess the issue is should we take a position and do something affirmatively with respect to this particular issue? Do we need to do that?
Well, I would like to see the State Board's final comments.
That's what I was curious.
I will attempt to get, whatever they finalize from the State Board and share those with the board.
Okay, that would be great.
To see, what they think needs to happen going forward.
Okay.
And then if, the board needs to take some action, we can take some action on it. But I'd like to see what their final comments are first.
Without really understanding all the analysis, I would think that it would appear to me that you could draw an analogy to a statewide contest, to a statewide referendum.
Correct.
That really should allow that ballot to be counted.
Mhm.
It seems like from a philosophical or say from a basic principle matter,
Right.
be a natural extension.
I can't disagree with
Yeah,
that.
okay. All right, you're going to switch hats now.
Switching hats here
All right, Ms.
to
Barone.
election judges.
Okay.
And thank you, by the way, for that consideration. And I'm always concerned about the timelines. And when I hear, a month in the legislature, I don't know if that's good news or bad news, but it doesn't give us a whole lot of time to enact the changes that will have to take place. In terms of election judges, we're working from the GOP side.
Sharon, I'm having trouble hearing you. Could you speak closer to the microphone or turn up the microphone volume, whichever might help?
Does this help?
Yes.
I'll use my old school teacher voice.
Okay.
The Republicans are gearing up immediately to begin the recruitment process, and we have the goal to have all 100% of our judges filled, let's say the end of July, the middle of August. And in order to accomplish that schedule, we have to get going right away. And one of the areas that we would like to, cooperate with the board is on the setting up electronic communications with the judges and an electronic database. The requirement of the party is to submit a certified list, and how we do that has traditionally been through paper. So one of the things that we're transitioning as a party to is to an electronic enrollment for election judges, not dissimilar to what Suburban Cook has, but also not that exact software interpretation. We're going to be using an applicant tracking type of software that's on the market. I have a background in that, and that's why we're going to work with it. So we would like, number one, to get the precinct by precinct notifications out that we're searching for judges. We've talked about it in the other prior meetings, what can we use to work together. We want to make sure that we have the actual application so that what we have for an online enrollment cooperates with what the information the board needs to track and to have for your services as well. And I have to come to you with the news that we have to do this really fast because timelines are just heating up. So we would like to have the notice go out to all of the Republican judges that we're hiring and to get them to go ahead and say, yes, we want to be a judge for November by May 31st. And then immediately assign those judges according to their residential precincts. And then give them confirmation that this is where they're going to be placed. And that then allows us to identify all the other areas that we don't have filled yet. And we'll be running and asking our committeemen to have a much closer deadline to the end of July for completing all of their appointments too. And fundamentally, what we're trying to work with is to alter the way that judges are recruited, rather than, and from an administrative perspective, legally, you guys get the power at the 45-day period, so it would be natural that you would work with over-the-counter applications. What we're trying to do is to drive the election judges to the committeemen so that they can choose from them much more in advance of that end of that period. And the only way to do that is by going precinct to precinct recruiting, as we've talked about before. So I'm not sure who to work with at the board. I know Mr. Goff is a very busy man, and so I just want to, kind of get the direction to go forward. First step, we need to have the judge application. I know I need action points here. Secondly, we want to work with you on electronic communications with our judges and enrollments.
Well, do we have electronic?
Just let me make a comment.
Yeah, just a global comment. You don't have to get
comment.
down into the details.
I
don't
won't
think.
get
Okay,
down
yeah.
into the details,
Okay.
but just to let you know, we just received Ms. Maroney's letter yesterday.
Yeah, I did
I
review
have
it.
not had a chance to meet with staff. I was talking to Kelly. She just received it.
Mhm.
So I'm going to meet with staff and see what we can and cannot do. So
Okay.
as soon as we do that, I'll be shooting off an email to Ms. Maroney to let her know what we can and cannot do.
Okay.
But I just, we have not had a chance to review it yet.
I did review your email.
Thank you.
And it's comprehensive.
Yes, sir.
So I understand that the staff needs a little time to work through it. You obviously have thought through this and spent some time with it, so give us a chance to digest it, take in what we can work with you on, and tell you what we can't work with you on, and move forward.
Thank you very much.
Okay. All right. Terry, anything from you today?
I don't believe so.
All right. We have Ms. Wilson here. Hello. You're not required to talk. I just want to acknowledge you and recognize you, your presence. So thank you for being here today.
Thank you.
Well, that will conclude our meeting. And
Mr. Chairman,
yes,
just before we adjourn, and Commissioner Cowan is on the line. Commissioner Cowan, do I have your permission to sign your name on the letter to Rio Movers and Van Lines?
Yes.
Okay, thank you.
all righty.
Motion to adjourn?
I would say that there's a typo in my name there, but we'll Langdon. That's okay. I've only been here 17 and a half years. Sorry, Jim.
Sorry, Mr. Chairman.
Sorry. That's a low blow. I'm sorry, Jim.
It's deserved. It's deserved. Sorry about that.
All righty. On that humorous note, I'll accept a motion to recess until our next regularly scheduled meeting, which will be May 13th at 9 o'clock. Okay. Motion to
I
adjourn.
think Commissioner Hernandez moved to recess or adjourn. I'll second that
All
motion.
right. All those in favor?
Aye.
Okay.
Aye.
Thank you,
Thank you.
Commissioner.
Yes, I will plan to be there in person on the 13th.
Great. We'll look forward to seeing you.
Thank you.
Okay. Sorry, Jim. I had to